and he's going to do our training today on courtroom testimony. And Rob, I'll just let you introduce yourself and just get right into it.
Perfect. Can you guys hear me okay, everybody? Is that a yes? All right, well, first things first, my name's Rob Nelson. I've been with Bannock County for probably about close to 20 years now. Before that, I was a police officer in the Bureau of Police Portland in Oregon, and a long time ago, so not during all the craziness, but I was also worked with Hillsborough Police just outside of there. Before that, I was in reserves and cadets and the whole gamut. So kind of a bit of a background and a little bit of experience, at least in Bannock County. And that being said, my feeling is that we're kind of a culmination of everybody's experience that's present. And I like to do things pretty informal. So I really don't just want to sit up here and read off a PowerPoint or something else. So if you guys have some experience or something else that you could add to this conversation, I'm all for it. And please do. No need to raise your hand or whatever. Just interject whenever you think you have something great to say. I'm all for that. Forgive me for my ignorance with Zoom, but I'm going to share the screen here, and I hope it's going to work. Can everybody see that okay? Is that a yes? Okay, cool. Well, like I said, a few months ago, I was asked or voluntold in certain ways to do courtroom testimony. And there's a couple of things that I wanted to touch on beforehand when I got into some of this stuff, especially some of the technical things, and that's some of the presuppositions. And what are those? Well, presuppositions of what you've gone through as far as in post, you've completed the courtroom protocol class with Idaho Post. And I know some of the earlier misdemeanor posts did not have the courtroom protocol class, because I didn't have it and I don't remember it. But that being said, I'm hoping most of you have gone through that, or at least have a working knowledge of some of those things that they teach in the post class. And that being said, you passed the post, you passed your post test, you passed hopefully all of your questions regarding the courtroom protocols. And then you have a general knowledge of some of the things that I was kind of talking about before, probation, courtroom procedure, how those things work, generally how a probation violation comes to fruition after you file a violation, or after you file an agent's warrant, and then kind of work it that way. And those are some of the things that we'll talk about, obviously, coming up here pretty soon. But as the season is upon us, and I saw this funny cartoon, I'd let you read that real quick. It's kind of funny. That being said, hopefully everybody's having a good Thanksgiving and getting ready for that. But as with most post trainings, there's some objectives that I kind of wanted to cover. And honestly, I don't have a ton of time to cover a lot of stuff. And if you remember, I think the courtroom testimony was at least 2 to 4 hours in your post class. And that's a lot of information to cover. And I'm not going to cover a lot of stuff with regards to, like, your dress and your appearance and things of that nature. My hope is that you've got that previously in your post class. But some of the things that I wanted to cover were things I didn't know a lot about, which are the administrative stuff with regards to probation violations specifically. Obviously, the first one there's IRE 101. Does anybody know what IRE is? It's the Idaho Rules of Evidence. And believe it or not, there is a part of Idaho Rules of Evidence 101 that covers it's actually called miscellaneous hearings. And we'll talk a little bit about that once we come up here. We'll talk about agents warrants a little bit. If we have a lot of time, I put that at the end because if we don't have a ton of time, then I'm not going to cover that. And my hope is the same thing with your Idaho Post and some of your post classes. That was covered in pretty good detail. But some things changed, and I know specifically 2227 has actually had some amendments in 2014, maybe 2017, something like that. And a couple of things changed, some of the wording, and we'll go over that in specific detail if we have plenty of time. PV hearings, how evidence works, reports, prosecution. And I'm not sure who all is in attendance here today, but Bannock County, we're in the southeast of the state, and things are handled a little bit different. We'll talk about that differently, but evidence, reports, prosecutions, and how some of those things are significantly handled differently in a probation violation rather than like a new charge or something to that nature. IRE 101 E3, that's the rules of evidence, and rules are basically inapplicable, which are outlined in those rules of evidence in IRE 101. Does anybody know where the Idaho rules of evidence come from? Anyone? Bueller? Nobody? Well, the Idaho rules of evidence actually come from the Supreme Court of the state of Idaho. And that's who governs the rules of evidence with regards to our probation violations. And in IRE 101 E3, and you're welcome to look it up, Google, a simple Google search will take you right to that. It basically says straight up that the rules of evidence are inapplicable in those hearings. And it says these rules, except for those on privilege, do not apply to the following, which is us. Number 3, the following miscellaneous criminal proceedings: extradition or rendition, sentencing, granting or revoking probation, issuing an arrest warrant, criminal summons or search warrant, considering whether to release on bail or otherwise. And that, again, that's, I just extricated number 3 off of that. There's a lot more to the IRE 101 if you guys want to look that up. It's probably, it's stereo instructions, but it's great information to know when you go into court. And we'll go into more detail as to why. So what does that mean? Governed rules of evidence do not apply to a probation hearing. What does that mean to us? Anybody take a stab at that? What doesn't apply?
Hearsay.
Hearsay, what else? Anybody else have a stab?
The burden of proof is less for the state.
And what is the burden of proof? I just popped it on the screen, but it's preponderance of evidence. Does anybody know any other burdens of proof? And we'll talk a little bit about it more, but there's other burdens of proof than just a preponderance of evidence. And preponderance of evidence is one of the lowest burdens. Hearsay we talked about, and we'll talk more about in pretty good detail. Omission of evidence, pictures, information, objects, exhibits, etc. Basically, that means that when we admit evidence in a probation violation hearing, how does that work? Does anybody know? Basically, there's no rules, to be honest with you. It's a super gray area. And my suggestion is obviously get with prosecution, court clerks, judges, how they want to handle that. But in my experience, it's pretty informal, just so everybody knows. Examinations of witnesses, testimony, etc. That kind of falls under hearsay, but some of the rules that govern new charges or other hearings don't apply to this hearing as well. So be very well with that. And kind of funny, just on an off note, I actually hit the witness stand yesterday for a contested hearing, thinking about all these things. and we'll talk about that a little bit. But preponderance of the evidence. Does anybody have a working definition of preponderance of the evidence?
It's more likely than not that the individual violated the terms and conditions of probation.
Okay. More likely enough. And the burden of proof is on, guess who? The state, on us. probation and the state to meet that burden of proof. Otherwise, you guessed it, the judge will find them not guilty of the probation violation. Preponderance of the evidence is one type of evidentiary standard, and this is the definition. Under the preponderance standard, the burden of proof is met when the party with the burden convinces the fact finder, in this case, the judge, or in most probation violations, that there's a greater than 50% chance that the claim is true. So 51.49%, that's the preponderance of the evidence. Like I said before, it's the lowest burden versus here's some of the other ones: more likely than not, clear and convincing, beyond a reasonable doubt, probable cause, etc. And so everybody's clear, the probable cause standard is actually vernacular that's used in agents warrants, and we'll cover that more if we have plenty of time later in the end of the training. And if, like I said, if we have plenty of time, we'll cover that in detail. Next one is Karch versus Karch. Does anybody know or have heard of this case? This is actually a Pennsylvania case that talks about the preponderance of evidence and the requirement for that. And most courts, at least in my research that I've seen, a preponderance of evidence is actually is actually utilized in civil proceedings more than any other proceeding, which is interesting for us with regard to probation violations and probation hearings in general. Even setting probation or revocations of probation, even sentencings don't have to follow rules of evidence. And I've seen that happen. I've actually seen judges that will question defendants in sentencings totally aside and outside the bounds of the rules of evidence, and they're allowed to do that. When I first started back in 2003, I was assigned to a judge, and he was questioning a defendant that just was, if I can remember correctly, I believe it was like a rape that was reduced, and the judge did not like the reduction and did not like the stipulated reduction of that charge. He was asking the defendant a whole bunch of questions, and the attorney actually told the defendant not to answer the judge's questions. Yeah, I can imagine. You can imagine what happened with that. The judge actually put the public defender in jail, just so you know. It was quite something to see for me when I first started back in 2003. But anyways, back to the Karch versus Karch. It's to tip the scale slightly. It's a criteria requirement for preponderance of the evidence. And basically what we're saying, the 51.49, and to go forward, preponderance of the evidence is such evidence as leads the fact finder, which is the judge, to find a contested fact to be more probable than its non-existence. So after reading that, what's a good example of that? I kind of drew up a hypothetical example of preponderance of evidence. And you being probation officers, you supervise a guy named Dave, and you witness Dave at a bar. Is that a preponderance of evidence standard? Anybody? Yes, no, maybe, I don't know. I don't think it is. And when I hit the witness stand yesterday, specific details of one of the allegations was that I didn't witness the particular probationer at the bar, but 3 of the other POs that work here in Bannock County did. And the judge ruled that that was not a preponderance of evidence and wasn't enough for him. So we'll continue on, and you guys tell me when you think we get to that preponderance standard. You see him inside at the bar itself. Is that a preponderance of evidence? I don't know about other areas of the state, but judges here in Bannock County like to order no bars, period. You can't go into a bar. The primary source of income is alcohol. I didn't go into detail about it, but there is a case called under State v. Poston in the state of Idaho, that the Supreme Court heard, that they actually addressed that issue, if you wanted to look that up, State v. Poston, Poston. And I didn't put that in the presentation, but it's something really, really good to look at because it talks about judges taking judicial notice of a bar itself being a bar, and that's the primary source of income. But we'll go on. See him sit in the bar. There's glass in front of him with a yellowish substance in it. Is that a preponderance of evidence for consumption of alcohol?
I would say no.
Anybody?
I would say no.
One no. Anybody else?
I don't think you're there yet either.
Okay. Why or why not?
You could have just sat down.
Okay.
I also don't know what's in that glass. It could be lemonade.
Okay. Could have just order it. You guys are thinking like defense attorneys.
I
like
had
it.
I had a situation exactly like that recently.
Perfect. And that's awesome. That's good to know because, you know, you can dictate how you handle things in the future because of that. But we'll keep going. My example keeps going. So you ask him what he's doing there, and he said, "I'm drinking." And then you ask him, "What is he drinking?" And he says, "Beer." Is that a preponderance of the evidence? A lot of you are nodding your head yes. Why or why not? If you say yes or no.
Well, he just admitted to drinking it and he
Okay.
admitted that it was beer.
Okay. Okay, so why or why not is that a preponderance of evidence? Do you think that tips the scales? I guess you could say 51-49.
In my view, it does. You got an admission.
Okay. Okay, you got admission plus your own observations, plus he's in the bar, plus you witnessed him there, plus the glass has a yellowish substance in it. Training and experience tells you that this bar there's a lot of alcohol there. Whatever you can, illustrate in court, obviously, or in your affidavit, or probation violation. So let's keep going. How about next? You complete an evidentiary test, a breath alcohol test with a result of 0.064 there's a typo. That's 0.077, not 0.77. You'd probably be dead. Does that meet the standard?
You should be there.
Yeah, I think you're more than there, especially with the evidentiary test. Absolutely. Anybody else have anything to add to that practical situation? I added more just to go over the top, obviously for the training, but you also have him complete an ETG ETS test with confirmation, and it comes back confirmed 4744 ETG 3822 for ETS. That, in my opinion, that's definitely preponderance. That's probably over the top of preponderance. And in fact, it's way over probable cause. Probably close to clear and convincing. So, and we'll cover this a little bit more later, talking about evidence and stuff like that. But it's important to understand those examples and to understand when, especially if you're out doing bar checks or even at somebody's house, if you guys do that at your particular probation county or office, to understand where you are with the preponderance of evidence, and if you check mark those boxes in your brain, especially before and if you are going to arrest somebody. So moving forward, there are exceptions, and here's the exceptions. At least in my opinion, a lot of this is extremely subjective. How is this subjective? Well, because different judges will definitely interpret some of these statutes and even the rules of evidence completely differently than the next judge in the next courtroom in the same courtroom house in your county. And I've seen this over the states, and just talking to some of the probation officers over the time that I've been a PO, I've heard this. So be careful with that. And we'll talk more about that too. Not only judges, prosecutors, some prosecutors won't take cases or do things without certain evidence, without certain things behind that. And I'm sure it's a little bit different. Hopefully that your prosecutors prosecuting attorneys, private attorneys, public defenders, especially if they're seasoned, they know the rules of evidence in a probation violation. But some of the newer PDs and PAs and prosecutors probably won't. We'll talk a little bit about that too. And they all change over time. If you've been here 5 years or more, you probably worked through or past multiple prosecutors, multiple public defenders, and obviously private attorneys. At least in the Bannock County area, there's probably 60 to 70 that will work a criminal case, at least, or in the Bannock County area. But my point with that is they all change over time. Elected officials come and go. They retire, they find new jobs. A lot of public defenders and private attorneys, or excuse me, prosecutors, they're looking at going for a judgeship. And from what I've seen in that, they want to have as much experience as they can on both sides of the bench, on the right and the left, in order to make themselves look good for a judgeship position. And that's what I've seen and experienced. And we kind of talked about it too. Different locales obviously have different subjective matter and how they handle even preponderance of evidence, how they handle agents warrants, how they handle arrests, how they handle even probation violations purely. When I went to one of the first probation misdemeanor probation post to get the post certification, I learned that pretty quick, that other different areas of the state handle those things extremely differently. So my hope is that obviously working as a probation officer, you have the knowledge of that in your specific locale. And I think that's important to understand and see. My next slide is kind of a fun slide. Hearsay. And anybody know who this is? Probably pretty prevalent. Johnny Depp and Amber Heard and that whole big trial that happened earlier, I believe it was earlier this year, into last year. Deposition's been going on for 4 or 5 years. Anyways, I was just going to play a little video that kind of illustrated hearsay, which is kind of fun. If I can get it to play. Here we go. Well, it doesn't want to play. Anybody with significant PowerPoint knowledge know how to play this? Anyways, there were several times, if you remember, in the Amber Heard, Johnny Depp hearings, especially the ones that were well televised, where several times when Johnny Depp was, especially just Johnny Depp, was testifying, that they would constantly, there was a barrage of hearsay objections from the defense, or excuse me, from the, well, I guess it was a dual defense and dual prosecution on both sides, but they attacked him in every way they could to strike his testimony about testifying about what other people said. And that's the important thing about hearsay to understand, is you can't testify to what other people say in a specific case. And in probation violations, obviously you can. Oh, here it goes. anyways, you get the idea. There's of kind of what hearsay was and some of the debacle through his courtroom battle with Miss Heard was. But hearsay definition. Basically, it's information received from other people that cannot be adequately substantiated. The report of another person's words by witness usually disallowed by evidence. And like I said before, that is actually allowed in probation violation hearings. Kind of a funny what the witness said. But understand the witness didn't understand that principle with regards to hearsay in a hearing. And they heard him say it, so they wanted to testify it, and you can't do that in other specific hearings. Probation violations, again, you can. Hearsay, State versus Rose. Basically, the brief is on that case is defense appeal stating the district court committed irreversible errors by allowing hearsay testimony at a revocation hearing. And basically, the Idaho Supreme Court came back and said that it doesn't matter. The rules of evidence apply. There's a whole bunch of other findings from other cases, from other courts, not just the state of Idaho. And they upheld the, he actually had his withheld revoked. And that's one of the big things he was fighting. And they upheld the withheld revocation, and he actually was still on probation. But look that up if you have some time. State v. Rose. It's a pretty interesting case, just the facts and findings that they came from out of it, as well as some of the Supreme Court judges and the positions that they took on it. Evidence and entering evidence into the record. Like I said, it's extremely informal. It's difficult for the defense to object to your evidence, really. In fact, I don't think they have much ground to go on based on that with regards to evidence that you give. And some of you people that have been here for a long time, POs, and have provided evidence into court records, what have you put into evidence? Anybody? Video, audio, anything?
Drug test results.
Okay, yeah, that's a big one. At least for me.
Sometimes stuff you've contraband you picked up.
Okay.
You can also
Usually-
put in police reports on new charges from violating their probation.
Okay. Perfect. Anybody else have anything?
Admissions or signed appointment slips.
Sure. When they don't show up or whatnot, for sure. Great. And understand that different courts will enter evidence extremely differently. And what my experience, at least in the Bannock County area and in Bonneville and in Oneida, I've also been down to Bear Lake a couple times. Each of those places, it's extremely informal. And like I said, the defense has very, very little ability to object to any kind of evidence that comes in, especially with most of our agreements of supervision and the sentencing forms, especially if they have their Fourth Amendment waived, searches, etc., stuff like that. So just be mindful of that. Judicial notice. I was talking to one of my coworkers today about judicial notice. Be careful with that and understand what that is. Talk to your, I'm not going to go into significant detail, but talk to your prosecutor about what that is. We talked a little bit about the pictures and videos and recordings. I know at least when we started using body cams here in Bannock County, public defenders and private attorneys do not like videos for some reason. They do not want us to play videos in court. So just understand there's a reason for that. Speak with your prosecutor, clerks, judges, especially beforehand, to figure out what to do with some of that evidence and how to put it in. But just understand that that's kind of how it works. We'll pass that. Reports to court, obviously, most everybody I hope is using affidavits for probation violations, especially when it's required off of for Idaho 20-227. within 24 hours. Be well aware of that. Concise versus exhaustive. Now, in my experience, depending upon the violation, concise and quick, usually an affidavit for new charge. So-and-so was just charged and arrested for domestic battery on November 1st. And then give the case number if you have it. That's usually sufficient enough that I've seen, at least in the courts here in Bannock County. And then exhaustive, why would you want to have more information in an affidavit? And tell me an example. Anybody? Anybody? I would say, kind of like
Sorry,
what,
I was gonna answer and I couldn't unmute myself.
oh, you're fine.
I could be totally wrong too, but is it to show a pattern of behavior?
Yeah, I think that would be great. Yeah, absolutely. And kind of going on what Penny was saying earlier about police reports. You can enter information off a police report absolutely into your affidavit. And I've done that a lot. If you have the ability to get that. Sometimes it takes 3 or 4 days for a police report to come through, especially if there's no custody. So just be aware of that. So I put generally more information is best. Generally more evidence also is best. And like I was saying before about evidence, and to add a little bit more, a lot of times I've just taken pictures with my personal cell phone. Or if you have a county cell phone, just take a bunch of pictures of what you see. What are the general conditions of the house or home, or wherever you're contacting the client? Is there tons of beer cans? We did a home visit probably about a year ago where, I kid you not, there was a mountain about 6 or 8 feet high of twisted teas in his garage. I'm not kidding. A mountain of empty beer cans. Twisted tea, I guess. So be aware of that. Presumptive testing, confirmations, BRAC we talked about, ETG, ETS, saliva tests, or whatever other testing that you're doing. There's patches, there's all kinds of testing that is out there. But be descriptive in your probation violations, and even seasoned attorneys will have a hard time even trying to fight, and it most likely won't even go to a contested hearing, in my experience. We talked about just listening to the charge and being concise, judicial notice, other allegations of the PV, often more elaborative than a simple charge or conviction. Talked about that as well. Proving someone is positive to drugs or alcohol without presumptive evidentiary testing. My suggestion is get that presumptive evidentiary testing, even if it's the BRAC. Agent's warrants, basically all I really wanted to go over is that you have 24 hours to file your agent, at least an affidavit of probation violation after you put them in on an agent's warrant. Now, it's my understanding that there are some counties in Idaho where judges won't allow POs to utilize agent's warrants. And luckily on this side of the state, at least in Bannock County, our judges give us significant latitude that way, which is really nice. Another thing I wanted to talk about was prosecution and your relationship with your prosecutors. Educate them. New ones will probably be unfamiliar with everything that we've talked about today. The Idaho Rules of Evidence, especially 101. It's probably a great idea to kind of touch bases with your prosecutor, especially if they're kind of new or green, with regards to rules of evidence in a probation violation hearing, even if there's a minute chance that you're going to have a contested hearing. As new PDs or private attorneys as well, we just got a whole slew of new public defenders, and a lot of them are really new, and a lot of them want to make a name for themselves and save the whole world and the whole bit. So be well aware of that. Advice and legal counsel, my suggestion is to use your prosecution for advice and legal counsel. Judges are a great source too, and a lot of that depends on your individual judges. A lot of them don't like to do a lot of ex parte. So be careful of that, especially if you give them information on your cases that you're getting counsel for. Usually the judge I used to work for was really good for that. And I would just ask him questions specifically and kind of colorblind as to what information I gave him on the questions that I had. But usually I would ask him after the case was over or the PV was over, and he would give me great counsel on what to do or what not to do. Obviously, preparation, prepare your case as well, especially if you think there's even a minute chance of it going to a contested hearing with your prosecution, because that'll help you dramatically. Obviously, have your paperwork in order as well as your information, and your familiarization with the case, client violations, etc. I know I just switched caseloads, and it's kind of tough not knowing most of my clients and what's going on with them. And the converse is exactly true. Having all that familiarization and just knowing the background with the clients since they first were signed up for probation is a huge thing. So, be well aware with that.
Hey, Ron,
Yes, man. Yes, sir.
how will the courts, now that we're paperless, do they allow you to use your laptop?
That's a good question. In fact, that happened to me about a month and a half ago, because one of the public defenders objected to me opening my laptop, and there's absolutely no rules that apply to that. There is on new charges and new cases, etc., specific rules that specify they can and can't look at paperwork, affidavits, etc., but there are no rules that apply to that. And unfortunately, my prosecutor didn't know that, so he didn't object at all. So the judge just went with the objection and sustained it. So I couldn't use my laptop at all. I had no access to my notes whatsoever. So beforehand, like I said, with the preparation aspect, make sure you talk with your prosecutor and they're well aware of the rules of evidence, because you may wind up in that situation where you don't have that ability. Well, that's pretty much I had on at least the Idaho rules of evidence and some of the courtroom testimony, some of the things that I thought was extremely important to be well aware of, and hope you come away with some of this. Is there any other questions that anybody has? And I know we've gone over about 5 minutes, so. But if you have any questions, I can try and tackle them, or somebody else can. Anybody?
I had a quick question on hearsay. Would you go into hearsay can't be your only allegation that you violate someone on because it violates their 6th or 14th Amendment?
Well, yes and no. The determinant factor, at least in the research that I've done, is that they're post-conviction. Pre-conviction, it's a whole different ballgame. But post-conviction, all the rules of evidence change, at least in the state of Idaho. It may be totally different in other states. But federally, federal rights only apply to new charges, from what I've understood. And hopefully that answers your question, Doug. Anybody else have any questions or anything to add, or any cool cases that have come up that you can recall?
I have a question about when you take the stand, what questions do they typically ask to establish that you're PO and whatnot?
That's a great question. And usually, in my experience, they've only asked what you to state your name and spell your last name, some of your training and experience, and it's mostly abbreviated. Excuse me. And from my experience, it's very informal as well. I think the rules of evidence really don't apply to that either. I have never really ever ran into a problem of venue, where in probable cause new charges you have to show and prove that, but I've never had that in a probation violation. But they typically will ask you those things, training and experience, so be prepared for that. Obviously your name and how to spell your last name, hopefully you know how to do that. But obviously that's probably the biggest thing. I've had prosecutors go into real depth detail on training, and then I've had others that just ask me about certification to be a probation officer, and that's it. So in my opinion, I think more information that way is the best, especially if you're, most of my PVs deal with positive drug tests. Excuse me, sorry guys. And that's kind of a big thing, especially with your background and experience and training for presumptive tests versus GCMC CC tests and what those are. Most courts don't know what they are, judges especially, and they're going to lean on what you know. Anybody else have any questions? Sorry, my throat doesn't want to work with me here. So, well, that's like I said, that's pretty much all I have. If you have any questions, anybody else has any other questions, feel free. Anybody?
Do you have any
That's-
advice, like things that you've done terribly wrong that you'd like to share with us so we don't do them?
Well, I mean, the hearing that I hit yesterday, I didn't have a lot of evidence with, all I had was hearsay evidence that the 3 POs had seen her at a bar and that there was, alcohol in front of her. And the judge did not go with that allegation at all. So she was found not guilty of that violation. There were other violations in her probation violation, so she was ultimately found guilty, but that one was one of the bigger ones. And that's kind of how I framed the whole, here's an example of it. And hopefully that answers your question.
So Rob, do you have any advice on how to testify in evidentiary hearings when employees don't work there anymore? So you're testifying to the record versus it being your probationer and your personal experience?
Well, my suggestion is obviously you're going to have to do some groundwork. Your boots are going to have to hit the ground with regards to if they're not working there or they were fired or something like that. You're going to have to contact those people, get names. Obviously, as much information as you can is going to be better than the less information. Obviously, if they admit it or whatnot, I usually haven't ever violated just on that alone. Usually there's a whole string of other violations and I'll add that to the mix. Kind of like paying their fines and fees. If they don't pay their fines and fees, then that's something I'll just add on. But I won't violate them specifically just for that. Hopefully that answered your question. Anybody else?
Do you have any experience testifying in a preliminary hearing for a new charge? Like, for example, we did a home visit and found drugs. He now is pending a felony, was subpoenaed to testify in the new preliminary. So how does that differ versus a regular like PV hearing?
Absolutely. And it will differ greatly. One of the biggest things probably in hearings like that is to greatly illustrate that you are there purely for a probation violation. Any investigatory process that you take is purely for a probation violation. And then fruits of that will actually be accepted in the courts pre-crime as well. And it follows rules of evidence beautifully. And in my experience, private attorneys and public defenders hate it when they're on probation, and new charges that come as a source of a probation violation check or a home check or something like that. It's pretty much a done deal because they can't fight that. But yes, it's greatly different. It obviously all those are going to follow rules of evidence. But once you illustrate that I was just there for a home check, I was there mostly just to take care of the probation violation, do a home check for probation, and there was a needle on the table, or there's kids running around, there's needles all over the place or whatever else. And then the fruits of that, obviously I would call police at that point and instigate a criminal investigation that way as well. I've also had in the middle of the night, police call me and say, hey, we're out with so-and-so. He's been drinking and here's what's going on. And immediately I tell them, you can do a breath test. You don't even have to go through the whole process of a DUI investigation. And then if they breathe positive, then they can do their own DUI investigation aside from that information. And that'll only help their case too. And hopefully that helped answer your question.
Yes, thank you.
Sure. Anybody else?
Well, Rob,
Amber?
I appreciate you being here today and your presentation.
Sure.
And just so you guys know, if you fill out a roster and send it to me, so how it works is we send them all in together. So you can get post credit for these trainings that we put on as a misdemeanor training council. So just send them to me, Carrie Anderson or Sandy Jones, and she'll get them to me, and then we submit them all together. Sometimes people have had problems when they send them in separately, just because post doesn't know exactly what the training is. So when they all come together, it seems to be a little bit more seamless. And
does everybody have your email, Carrie?
my email is kanderson@adacounty.id.gov. And if you guys have any ideas for future trainings, please email me, or if you're dying to do this, like Rob just did, we appreciate him so much for doing this. If you're dying to do it as well, we would love to have you. So just let me know if you have any ideas or any expertise that you would like to share. And for your coworkers that didn't get to see this, we did record this training so that they can watch it at a later date. And we'll send that email out to you with the information. That will probably come from Sandy. And Rob, did you see Connie's comment about, can you send out more info on the laptop?
Oh, the meeting chat?
Yeah.
More information on referring to a laptop. Where do we find the difference of referring to information for new charges versus probation violations? I think she means just the Idaho rules of evidence, and that's where it covers. And honestly, it's a super gray area inside of Idaho state code and case law, etc. So it would just, I'm sure it would just fall under the IRE. They should. Your prosecutors absolutely should be challenging that. So my suggestion is go talk to your prosecutors and say, hey, well, I just got away from some training for the rules of evidence in 101 E3. What can you tell me what's up with that? Why aren't our judges falling in line that way? That's what I would do. That would be my suggestion, and let your prosecutors challenge that, because you absolutely should be able to, especially the counties that are using and utilizing all their files and information inside of Odyssey. How else are you gonna? I don't know about you guys, but my new caseload, I have like 160 people that I have to keep track of, and it's really difficult when they have specific questions like, you know, in such and such a week of 2022 or 2021, when did they test? I can't remember that information. I can barely remember when I go downstairs what I went for. So yeah, and that's where I would, like I said, I would suggest go talk to your prosecutors, get a really good relationship with them, and then work it that way.
Thank you, Rob.
Absolutely.
Well, if there's nothing else, And I'm sure, Rob, they can contact you directly too, right?
Yeah,
if they have any
absolutely.
Questions.
Sure.
And so do that if you have any other questions, but we appreciate you all for being here and enjoy your Thursday. It's almost the weekend, guys. Have a
And
good one.
happy Thanksgiving as well.
Yes, happy Thanksgiving. Thank you.
Thank you.
Rob. Thank you, Carrie.
Thank you.
Have a great day.